The Indian Parliament, in a move that has ignited widespread debate and dissent, passed the Waqf Amendment Bill of 2025. This bill, now awaiting presidential assent, seeks to amend the Waqf Act of 1995. It proposes significant changes to the management and control of Waqf properties, the charitable endowments that hold immense religious and cultural value for India's Muslim community. The bill has been met with fierce opposition, with critics denouncing it as an assault on the religious freedom of Muslims and a blatant attempt to usurp control over their institutions. The passing of the bill has triggered protests across the country, with Muslim organizations, opposition parties, and civil society groups voicing their deep-seated concerns. The bill's journey through the legislative process has been fraught with tension, reflecting the deep divisions it has exposed within Indian society. As the nation awaits the final legal hurdles, the future of Waqf and the rights of those it serves hangs in the balance. To comprehend the gravity of the situation, it is crucial to understand the profound significance of Waqf in Islamic tradition. Waqf, an Arabic term that translates to detention or preservation, represents a unique form of charitable endowment deeply rooted in Islamic law and practice. It involves dedicating property or assets for religious, educational, or charitable purposes, ensuring their perpetual use for the benefit of the community. These endowments, made by Muslims during their lifetime or as part of their will, are considered irrevocable and inalienable, held in trust for generations to come. Waqf properties in India encompass a vast and diverse portfolio, ranging from grand mosques and bustling madrasas to serene graveyards and humble orphanages. They serve as vital pillars of the Muslim community, catering to their spiritual, educational, and social needs. These properties, often bequeathed centuries ago, stand as testaments to the generosity and foresight of past generations who sought to ensure the well-being of their community in perpetuity. The management of Waqf properties in India has historically been entrusted to independent bodies known as Waqf boards. Established under the Waqf Act of 1995, these boards operate at the state level, overseeing the administration and governance of Waqf properties within their respective jurisdictions. The composition of these boards typically includes Islamic scholars, legal experts, government nominees, and elected Muslim representatives. They are tasked with a multifaceted role, encompassing the registration of Waqf properties, the resolution of disputes, the generation of revenue from Waqf assets, and the utilization of these funds for the intended charitable objectives. However, the government, in its rationale for the new bill, has levied serious allegations against the functioning of these boards, painting a picture of mismanagement, corruption, and a lack of transparency. They argue that the existing system has failed to prevent the encroachment and illegal occupation of Waqf properties, leading to the erosion of these valuable assets. The government further contends that the boards have been inefficient in generating revenue from Waqf properties, hindering their potential to effectively serve the community's needs. These criticisms, however, have been met with skepticism from opposition parties and Muslim organizations who view them as a pretext to justify increased government control over Waqf affairs. The Indian government, led by Prime Minister Narendra Modi's Bharatiya Janata Party, has staunchly defended the Waqf Amendment Bill, framing it as a necessary step towards transparency, accountability, and modernization in the management of Waqf properties. They argue that the bill is not an attempt to seize control of Muslim religious institutions, but rather a well-intentioned effort to streamline their administration and ensure that they are utilized effectively for the benefit of the community. The government maintains that the changes introduced by the bill will bring greater transparency to the functioning of Waqf boards, making them more accountable to the public and reducing the potential for corruption. Furthermore, the government contends that the bill will empower the Muslim community by giving them a greater say in the management of Waqf properties. They argue that the inclusion of non-Muslims on Waqf boards, a controversial provision that has drawn sharp criticism, is intended to ensure fairness, impartiality, and adherence to the law, rather than interference in religious matters. The government's narrative, however, has been met with suspicion and distrust by many within the Muslim community, who view the bill as part of a broader pattern of attempts to marginalize and disenfranchise minorities. The Waqf Amendment Bill aims to bring a new order to the administration and management of Waqf properties. By introducing stricter regulations and more transparency, the bill seeks to ensure that these properties are used effectively and for the benefit of the community. However, it's important to consider the potential challenges and the impact on the stakeholders involved. As with any significant change, there will be a period of adjustment, but the goal is to create a more accountable and efficient system. This new order could pave the way for a brighter future for Waqf properties, aligning them more closely with their intended purposes. Let's dive into the concerns over rights and control. Many stakeholders argue that the Waqf Amendment Bill undermines the autonomy of Waqf properties. They fear that this bill could lead to increased government interference, which might, compromise the intended purpose of these endowments. Critics also point out that the bill lacks adequate safeguards to protect the interests of the beneficiaries. Moving on to the legal challenges, several organizations have questioned the constitutionality of the Waqf Amendment Bill. Legal experts argue that the bill might infringe upon the fundamental rights guaranteed by the Constitution, particularly the right to manage religious and charitable endowments. They believe that the bill could face significant hurdles in the courts. The Waqf Amendment Bill has not only sparked domestic debate, but has also drawn international condemnation. Various international human rights organizations have voiced their concerns, stating that the bill could lead to violations of religious freedoms. Advocacy groups are calling for, a more inclusive dialogue and urging the Indian government to reconsider the bill's provisions. Finally, let's look ahead to the future of Waqf in India. The ongoing debate over the Waqf Amendment Bill highlights the need for a balanced approach that respects both the autonomy of Waqf properties and the necessity for transparency and accountability. The future of Waqf in India will undoubtedly depend on finding common ground that addresses the concerns of all stakeholders while preserving the integrity of these important endowments.